what they're doing in their day-to-day struggles to combat workplace fraud in their states. I also want to thank our colleagues at the Comptroller's Office, Maria Robalino, who suggested this and thought it would be a great idea to have some colleagues from other states come and share best practices and thoughts. So with that, we know we have a lot to learn. Let's get into the discussion. I think I will turn it over to Commissioner Burke to kick us off and moderate the conversation.
Thank you so much, Secretary Wu. I'll echo all of that. Delighted to be here and to be joined by our colleagues who are tackling many of the same problems. Our hope today, I think, is to try to learn from all of your respective efforts in this area, what worked, what didn't, what you might do differently, what your recommendations are for us as a sort of newly revitalized task force dedicated to addressing this issue in Maryland, what recommendations you might have for us on paths that we could take. What we're hoping for in the format that we'll be working in is I'm going to introduce each one of you to give at least a taste of your amazing backgrounds and credentials to the task force members. And then we'll go right into the presentations. And I think we'll start with Minnesota, go to Illinois, and then Pennsylvania. Then we'll just open it up for a Q&A from the task force members. I do think it would be helpful probably for the task force members who are present to identify themselves. I don't know if we have a full list. We did a couple of introductions on people who came a little bit early, but that might be helpful. Portia, I don't know if you want.
Yeah, I apologize. I think I was supposed to do that and I didn't. Let me try to figure out if I can do do I have a quick list to run down? Here I do. Okay. First, let me see who we have. Oh, this is not easy for me to do with all these folks. We have a bunch of people on, I think, from the Department of Labor. And if it's all right, I'm just, I think it's kind of hard to popcorn around. So I'm just going to sort of list off their names and say who they are. We have our Assistant Attorney General, Sarah Harlan, Policy Advisor, Sapna Mehta. We have Sandeep Parikh and Traylene Putnam, I think, from Labor and Industry. We have Meg Rextis, who's our Deputy Assistant Secretary for Unemployment Insurance. Ashley Sharp from the Office of the Secretary. Rachel Torres, our Assistant Secretary for Unemployment Insurance. Of course, Commissioner Burke. Diana Winnick, our Director of Communications. And then me. And then I'll turn it to, I know, Maria, I see you on. I actually was crediting you for the genesis of this meeting. So apologies for a little difficulty in the technology, but from the Comptroller's Office, you quickly want to introduce yourself?
Sure. Thank you so much. I know my name shows up as Matt Bauman, but he shared the link. But it's Maria Robalino, Deputy Controller for Communications and Public Engagement. Thank you so much, Secretary Wu, for that.
Anyone else from the Comptroller's Office? Then from the Office of the Attorney General?
Wait, I think we have one more from the Comptroller's Office.
Oh, okay, sorry.
Is Matt here?
Yes, I'm Matt Bowman with the Comptroller's Office, one of our Assistant Chief Auditors, and I believe Terry Nelson's also on the call from our office.
Yes, I'm here.
Wonderful, welcome. Sorry, I'm not seeing everyone in the tiles, so I can't always tell. Did we get everyone from Comptroller? Terrific. Office of the Attorney General, sorry, Heather.
Hi, good afternoon. I'm Heather Heilman from the Maryland Office of the Attorney General. I'm glad I finally made it onto this meeting.
Any other colleagues from your team?
No, I'm in.
Okay, great. MIA, the Insurance Administration.
Hi, Secretary Wu. This is Marie, Acting Insurance Commissioner for the state of Maryland, and my colleague Robert is on the phone as well, so I'll have him introduce himself.
Hi, Robert Gwen, Associate Commissioner of Fraud and Enforcement for the MIA. Nice seeing everyone again.
Great to see you. Thank you for being here. And Workers' Comp Commission. Commissioner Quinn, I thought I saw her.
I don't think she's on or she's not yet.
Okay, great. Apologies, task force members. Have I missed anyone?
I believe we have Bob Yeager from SDAT as well. And then circling back, I believe we have an O&P representative from labor as well.
Oh, I'm sorry, O&P. I missed you. Yes, Sarah. Sarah, are you on?
I'm here. Yep, Sarah McDermott.
And Maureen Quinn, Chairwoman of the Workers' Comp Commission.
Oh, good. I'm glad you're here, Chair. Great. Okay, thank you. All righty. Thanks very much. With that, let me turn it back to our panel.
Yeah, Bob Yeager
Bob.
from SDAT. I think you're on.
Yes, I am. Hi, Bob Yeager, Deputy Director of SDAT. Great to see everybody, my old labor buddies. Great to be with you today.
You look very comfortable, Bob. That's all I can say. It's a large couch. You should have had the meeting there. But
I usually have a fancy virtual screen behind me, but you know.
This one's better. You should
Nothing
just
to
like take
do.
a picture of it. Yeah.
Right.
So great. So it's wonderful. I believe we have all of the agencies who are members of the task force represented today, and that's really a testament to how important this conversation is, and how grateful we all are for the time and energy that our sister states have given today. So without further ado, and with some shortening of these amazing glowing biographies, let me just run right into it. So first up will be, and I'll go through all the bios first, and then we'll start with presentations. So first up, Nicole Blissenbach, who is a Commissioner of Labor and Industry. Nicole, if you want to just wave your hand, because I know we're all on tiles, and thank you. So Nicole, she served as Commissioner of the Minnesota Department of Labor and Industry since January of 2023, and was temporary commissioner before that, since August of 22. Prior to assuming that role, she served as the deputy commissioner and directed the work specifically of the Labor Standards Office and Minnesota OSHA, and the compliance work, and as well as the consultation program under Minnesota Safety and Health program. Oh, I'm sorry, and the Office of General Counsel, Research and Statistics, and Project and Planning Work Units. That kind of sounds like everything, but I'm sure you have even greater responsibilities now as commissioner. So she's been at Labor and Industry in Minnesota since June of 2019, when she started as an assistant commissioner, focusing on enforcement and compliance strategies and partnerships. Previous to joining the state government, Nicole worked at Education Minnesota, which is the union, I believe, the merged union between AFT and NEA in Minnesota, representing teachers and professional and paraprofessional and support workers throughout the state. And she served in that capacity as an attorney in the legal department for nearly 10 years. And before that was a private law firm, at a private law firm practicing labor and employment law. She is also in her current capacity, a member of the Minnesota Attorney General Ellison's advisory task force on worker misclassification, and has held that role since the fall of 2000, it says 2003, but I think that means 2023. And she also leads an intergovernmental misclassification enforcement and education partnership, which was something that was created in the 2024 legislative session to allow the 5 Minnesota government entities that were tasked with investigating workplace fraud or misclassification to share their reported violations of the law and share related data so that they could better coordinate education, investigations, and enforcement. We're really excited to hear from you. It sounds like you are farther along on the path than we are, but very much in the same on the same track. So we look forward to your presentation. Next up is Jane Flanagan, who is the director of the Illinois Department of Labor. Thanks for waving. She was appointed to that role in February of 2022. And prior to her appointment, she served as Deputy General Counsel and Deputy Chief Compliance Officer in the Office of the Illinois Governor. And she provided counsel on legal and regulatory matters across a portfolio of state agencies with a focus on labor standards enforcement and workforce training. She is the founder and former chief of the Workplace Rights Bureau in the Office of the Illinois Attorney General, and under her leadership, that office drew national attention to the widespread use of non-compete agreements for low-wage workers. They negotiated 4 federal consent decrees involving labor trafficking in the restaurant industry and led multiple state-level legislative initiatives, among many other things. But the real crowning achievement in Jane's biography is that she began her legal career in private practice representing workers in employment matters. And then before she relocated to Illinois and left us, she was legal counsel to Maryland's Commissioner of Labor and Industry in the Office of Attorney General here in Maryland. And I know we have Sarah Harlan and Jenny Baker on as well, who certainly knew and fondly remember their colleague. I'm glad to reacquaint under these circumstances. I really look forward to hearing from you as well. And we have lastly, Christopher Halleck from the state of Pennsylvania. He served as Deputy Secretary for Safety and Labor Management Relations in the Pennsylvania Department of Labor and Industry since 2023, last year. And in that role, Chris oversees the Bureau of Labor Law Compliance, the Bureau of Occupational Industrial Safety, the Bureau of Disability Determination Services, and the Bureau of Mediation. He joined Labor and Industry after working in the Pennsylvania Office of Attorney General's Fair Labor section, where he worked since March of 2018. And during his time with the Office of Attorney General, Chris helped broker agreements with national restaurant chains, led multiple multi-state investigations, resulting in better terms of employment for workers, and resolved matters that affected workers for theft relating to violations of the Pennsylvania Prevailing Wage Act and federal Davis-Bacon. Prior to joining OAG, he spent the first 8 years of his career working for law firms that specialized in civil litigation and municipal law. We are delighted to have all 3 of you with us. And with that, I think we'll just roll right into the presentation. So Commissioner Blissenbach, you are first up. And Ashley, I think you have the secret code to sharing Minnesota's presentation.
Thank you. As that's coming up, I feel like I have to make known my Maryland connection. My mother-in-law was born and raised in Maryland before she came to Minnesota, so still have lots of extended family members in Maryland. Been there a number of times, so it's really great to be here. It's great to share the path that we've been on in Minnesota, but also be able to hear about the paths that other states have been on, because as was mentioned at the beginning, this is an issue that no state is alone in, and the only way we can get to a place where we are all better is by learning from each other. So really happy to be here. So you can go on to the next slide. So in Minnesota, we've kind of taken a lot of different paths, but all of them are at the same time. So you're going to see a lot of kind of parallel connecting pieces in the misclassification world. One of those pieces is the Minnesota Office of Legislative Auditor began an audit looking at misclassification or workplace fraud in Minnesota. That audit report was released in March of 2024. And one thing that I think became very clear in this audit was something we all know, but it was nice to see it in writing with Minnesota specific data, is that we don't have enough data on misclassification, where it's occurring and the impacts it has. One of the places the audit specifically looked is at the data that the Department of Employment and Economic Development, which is the agency in Minnesota that unemployment insurance is run through. The report looked deep into their data from 2007 and 2018, looked at the audits that had been conducted as part of the unemployment insurance program, and saw that there was a rise in misclassification from 2007 to 2018. In 2007, about 17% of randomly audited Minnesota employers misclassified at least one worker. And then in 2018, that percentage was about 22%. What that does not capture is everybody who was misclassified who was not where the employer did not show up in the unemployment system at all. So which we know is a big problem, but it does give us some bit of information about even those employers that are showing up in the unemployment system, that do have at least one worker that they report into, that even their misclassification is on the rise. So next slide. In addition to that audit happening, Attorney General Keith Ellison created an advisory task force on worker misclassification. What you see up on the screen is really what the scope of that task force was. That task force is made up, and it's currently ongoing as well, is made up of 15 members from worker advocacy groups, from the business community, from the public at large, as well as a number of representatives from Department of Labor and Industry. I serve on that task force. DEED, where we have the Deputy Commissioner who oversees unemployment, as well as our Department of Revenue for the tax implications. But really what that task force was charged with was taking in lots of information, data from a number of different sources, and to look at different ways to come up with a set of recommendations for both enforcement reform and regulatory reform to better tackle the issue. So that task force, and I think I have this on the next slide, started meeting last summer, or actually started meeting in the fall. The task force members were named last summer, started meeting in the fall. And one of the first items of business for the task force was to come up with a first set of recommendations. That first set of recommendations, and I know this is really small, you can also find this on the Attorney General's website in Minnesota, really focused in more on the government role of investigation and enforcement. And these recommendations were adopted in February, and they formed the basis of a legislative package. I think I failed to mention, two of the members of the task force were a current representative in the Minnesota House and a current senator in the Minnesota Senate. So these recommendations formed the basis for a legislative package that went through the 2024 legislative session. So you can go to the next slide. And I realized as I was putting the slideshow together, nobody else is going to know what that picture is, but that's the picture of our rotunda at our Capitol. So that's the connection to the legislation that passed. But the legislation that came out of the task force recommendations did a lot. It was a very large bill, and it created, so this is kind of like a brief overview of everything it did, but one of the most important things, and I'm going to spend a little bit more time on this later, is it created an intergovernmental misclassification enforcement and education partnership. I think that that's probably a very good comparison to what this group is. So that partnership was created and was in statute and was given very specific duties and obligations in the legislative language. It also really focused on strengthening the independent contractor test for construction. In Minnesota, we have a number of tests, but we have construction has been a separate test since I believe 2007, and it has been just been applied differently. It kind of got a little outdated. We found through all of our work enforcing that some of it wasn't workable, and so we really took a close view at that to look at what would make our enforcement efforts more effective, and learn from some of the challenges that we had faced. So took an eye towards strengthening that independent contractor test in the construction industry. We also created a private right of action for misclassified workers. And that goes along with the fact that we also now have as a separate cause of action in Minnesota, misclassification. So not only do you have the downstream effects of misclassification, like failure to pay unemployment insurance, failure to follow wage and hour laws, earn sick and save time, the tax implications, but There's also now clarified prohibited activities in both the construction industry and in other industries that directly identify things that are their own violations. Then attached to those clarified prohibited activities, we also used increased penalties and other deterrence mechanisms to make it so that the benefit that, and sorry, I think we're showing, okay, there we go. The benefit of violating the law, which we know there are incredible benefits to employers who want to avoid obligations by not following the law. We knew that we needed to make the deterrent at least as effective as the incentives to violate the law. So increased penalties to provide that meaningful deterrence was also part of the package. We also established both independent and successor liability for misclassification violations. We had experience on far too many occasions, the same people popping up in different employer entities. So you have violations of law, action is taken, a couple years later, new employment entity, same violations happening, and unable to connect it or unable to meaningfully connect it. So this legislation established that independent and successor liability for bad actors that are forming new entities. And then also learning from some of our sister states, expanded our stop work order authority to cover misclassification violations in industries other than construction, and expanded that stop work order authority. So it was a very big lift, but it was a package that worked together and was really informed by all of the entities that you now see on your screen, which are part of the new partnership that was created. So we have the Minnesota Department of Commerce, who regulates the insurance industry, and within the Department of Commerce, we have the Commerce Fraud Bureau, that can take action on criminal action on financial crimes, but specifically insurance fraud. So they are included in the partnership. The Department of Revenue for the tax implications, the Minnesota Department of Labor and Industry, we oversee work comp is in our purview, wage and hour laws, earn sick and save time, number of different other workplace laws. Then we have the Department of Employment and Economic Development, which houses unemployment insurance. And then our Attorney General's office, which has much of the same authority that the Department of Labor and Industry has over wage and hour laws. So these are the 5 government entities that are coming together in the Enforcement and Education Partnership. Next slide. So the main piece of of forming this partnership, but also making sure that there is some accountability, is having it directly in the legislation. So we have been very directed to coordinate and collaborate, as well as information share. The legislation directs the partnership members to communicate with other entities to detect and investigate employee misclassification. It gives authority to request from and provide data that is necessary for detecting and investigating misclassification, allows us to collaborate with one another when investigating misclassification, including things like referrals, strategic enforcement efforts, and joint investigations. Next slide. So the duties that are set forth in the law include setting goals that will help maximize all of our efforts from the different agencies, sharing that information, developing a number of processes and procedures to give relevant information. There was a lot of talk about whole of government approach to addressing this issue. And that has led to, I think, a renewed interest in the joint work, not wanting to recreate each other's investigations, learning how to work with each other to get that information back and forth, so that while it may be a big lift now, it'll make things easier in the future. There was also a lot of emphasis placed on no wrong door as it relates to workers. So, you know, we're all used to getting a call or a contact and we say, oh, that's not us. You know, if you have an unemployment insurance complaint, you need to contact Deed. But what we're really focusing on in the partnership now is creating that unified point of contact for workers, businesses, creating a unified set of information, outreach, talking points, education, to really just increase the overall effectiveness of the work that we are doing in detecting misclassification and investigating misclassification, in educating about how to properly classify workers, and just carrying out all of the duties that relate to misclassification. Next slide. We've also been specifically charged with public outreach. So labor and industry is kind of taking the front, the majority of the responsibility on this side of things, to give that you know, one place to go for all of the information. So we are currently building, we have a website up, but we're working with our other partners to better populate that website with information about what we're doing, you know, how to properly file a complaint, the information, you know, and I don't know what other states are like, but we have a lot of different tests and information about those different tests and how it applies and how to work through that. So that public outreach, that external facing information, making sure it's coordinated amongst the entities. And there's been a direction that each partnership entity has to maintain information on their website, but also point to the other entities and what the other entities do. So I think the partnership just started meeting. It became effective in July of this year. So we are, I think, 4 meetings in, but the partnership has also created a number of work groups. And I think you can go to the next slide. So we began meeting in July. We've established 4 work groups. Those 4 work groups have been tasked with coming up with protocols and procedures for data sharing, for how we are going to conduct those joint investigations and enforcement, how we are going to approach the education and outreach on these topics, and then probably most importantly, what are we going to do to get the data that we don't have and that really has been evasive, collecting that data and being able to report out on it and doing that analysis of what we're collecting. We have been also charged with reporting back to the legislature each year on what the partnership is doing, where we're seeing advances, where we continue to have challenges, if we need more resources. And so that is something that will be ongoing in the data collection efforts as well as reporting efforts. With all of that, we also still have the AG's advisory task force. The task force is still meeting and will continue meeting through the spring of, that should be 2025, spring of 2025. So the final report will come out in the spring of 2025 with any further recommendations, as well as recapping what has already been done. So still a number of moving parts, but I can say, you know, well, it feels like we're at the beginning. I feel like we put much of the necessary things in place to start making an impact, to start having that whole of government approach, to start making sure that workers can contact us, can get the support they need and the resources they need when faced with this in the workplace. So I'm happy, and of course I will stay on for more questions. I'm hoping I stayed within the 15 minutes, but thank you very much.
You totally did, and you packed a ton into it. So thank you for all of that. I've been like writing down my own questions, but I know other task force members will have them too. But I think what we're going to do is actually just roll through the presentations and then just have a discussion with hopefully with all of our presenters on with the task force members. So Jane, Director Flanagan, you are up.
Jane's just fine. Are you going to share the, yes, perfect. So it is, as Commissioner Burke mentioned, this is a real full circle moment for me because I think I was this task force's first like staffer. I actually can recall making the copies like of the agenda and putting them out in a room because of course we couldn't meet on Zoom in 2008 when that was my job. So life is weird and it comes full circle sometimes, and here we are.
We are so happy to have the benefit of that sweep of history. So truly, thank you.
Yeah, so let's jump right in. I had a slide about the Department of Labor just so you understand kind of our role in combating misclassification sort of within Illinois. If you can go to the next slide. So it sounds like many of you, but maybe not like Chris in Pennsylvania, we're kind of, and not like Maryland, actually. The Department of Labor in Illinois enforces essentially all of our wage hour standards, our fair labor standards. We do not have UI, we do not have workers' comp. But we do enforce our what's called the Employee Classification Act, which I'll talk about in a few moments, as well as minimum wage, overtime, wage payment and collection, kind of all those core wage hour standards. Next slide. So my thought today was to give you guys a little bit just sort of an overview of the tools that we have in Illinois law that, you know, we have used in various ways to try to combat misclassification. And then really get into kind of some obstacles and strategies to overcome those obstacles, because I think the fact that in 2008 I was making the agenda for this task force reveals the fact that this is a huge challenge and it's really hard for public agencies to combat in effective ways. So that, you know, I just want to name that reality and think about, you know, what has worked and learn from all of you about what has or is working. Next slide. So one thing I do think is somewhat interesting in Illinois law and wanted to highlight is that we have a mandatory employee misclassification referral system and have had since 2008. It is housed at the Department of Labor. There is a single misclassification complaint form, which was required to be developed with partner agencies. And you'll see the partner agencies there, the Department of Employment Security, which is our UI agency here in Illinois, our Workers' Compensation Commission, our Department of Revenue. And we have essentially voluntarily, although the statutory language does not include the Attorney General, we have included the Attorney General because since 2008, as in Minnesota, our Attorney General's office has parallel enforcement authority and also represents all of our agencies when we go to court, right? So when we get a complaint in that seems to involve misclassification, that is automatically sent to our partner agencies. We can talk a little bit, I think, as we go on about pluses and minuses of that. I think the plus is that everyone's getting the same stuff. The minus, of course, is that many of those complaints aren't actionable, right? They have all the problems that complaints always have. Many of them are not actionable. They're outside the statute of limitations. They're not really about misclassification. And so our partners are not getting vetted strong complaints necessarily. They're getting all. But it does allow us then to talk about ones that seem to merit further investigation, right? And know that everyone has seen the same information and then is using their own tools to kind of go deeper. Next slide. So we also have and enforce this Employee Classification Act. It is a standalone violation for misclassification. It is limited to the construction industry, as I think many of those early, misclassification laws were. It does incorporate the ABC test. And then there is also kind of a carve out for legitimate sole proprietors, which are defined under the act. It also has a contractor reporting requirement. They are supposed to report to the department if they have used independent contractors in the past year. That my understanding is that requirement was not widely enforced. We have started enforcing it in recent years, essentially just issuing civil penalties. And I think, you know, we are seeing some compliance there, but I feel like it's sort of too soon to tell how effective that is or isn't. We do not have a contractor registry, which I know some states do. And then we also have a private right of action as well under this Employee Classification Act. Another kind of piece of our law that I want to highlight, because I think it's really can be very intertwined with misclassification, are joint employment tools. So we did a case a couple years ago. The Department of Labor and the AG's office did a case a couple years ago. This is all public, so I can talk about it, involving the Rivian electric vehicle plant in central Illinois was built. And we got word from community groups that it was being built with folks who were had been brought from Mexico, and kind of these layers and layers of like labor brokers and subs. And so, you know, one of these cases where is it misclassification? Is it just no classification? Who's on the books? And so for that case, for example, I think that was one where it was construction. So we were using our misclass tools in the construction industry. But we also really needed to establish upchain liability because so many folks were employed through, you know, a guy in a truck with a cell phone, essentially. And so I say this to say, like, I think that thinking about your joint employment law and how that ties in is useful for those kinds of misclass cases where you have kind of tiers of complex tiers of labor brokers and subcontractors. And we do in Illinois have this new, relatively new, couple-year-old amendment that provides for primary contractor responsibility for any wage claim down chain in the construction industry. It does only apply to private construction, so that's not our public funded prevailing wage kind of work. But we are just starting to test it, but theoretically that should really simplify the question of who's controlling and joint employment, and allow us, you know, for example, in that Rivian style case, to go after prime contractors, or at least contractors further up a chain that goes all the way down to like two guys in a truck. And then in our minimum wage law, we also recently issued a couple years ago joint employment rules that were also intended to kind of get at that question. Another just kind of point of interest I wanted to raise, I don't know how many of your states have False Claims Act. You know, so there is the Federal False Claims Act. For some of you who are lawyers, right, this is like a Civil War era statute meant to go after, you know, contractors that did shoddy work for the federal government, you know, in Reconstruction. But it does provide a vehicle for recovering, you know, when a person essentially makes a false statement to the government. And so I've got our Illinois language here. And we have seen in recent years, a number of qui tam actions. So where there's a private whistleblower that brings to the attention of in our case, the Attorney General's office enforces our False Claims Act, essentially misclassification, UI fraud. And they have used a false claims theory to attack misclassification. You know, these have largely, you can even tell from the names of these cases, they're all trucking and like delivery services and carrier cases. All of the drivers were independent. None of them were reported, you know, they did not pay UI. And so the theory is they were actually employees. This was a false claim to the government. They deprived them of the, you know, the state of these taxes. And so far, these cases seem to be proceeding successfully. So I don't know what the case law is in each of your states, but I just wanted to raise it as a kind of another tool that seems to be possible, promising. Next slide. Okay, so challenges, I was really thinking about this, and I'm interested in all of your thoughts on what are the challenges. I'm sure I haven't named them all. A few things we see. Our staff that enforce the Employee Classification Act really have a hard time finding workers that will talk to them. And because folks don't tend to keep really good records of, their true off the books employees, I think for those kinds of cases, particularly in the construction industry, that can be a big barrier, right? It's hard to prove up some of these cases without having any worker testimony. Another kind of challenge that I think many task forces have run into, and we certainly have run into, I should say, we don't currently have a formal task force in Illinois. It's sunsetted. But our kind of staff level folks continue to meet. The folks that get our referrals continue to meet kind of quarterly. But yes, we continue to bump up against limits on information sharing, particularly from our departments of revenue and our unemployment insurance folks. One way, well, I'll talk about strategies in a minute. Another challenge, I think, is just, changes in administration, changes in principles. Sometimes this is a thing that's being focused on, sometimes it's not. And that is why I think that the staff level communication is really important. And then I think staff training is another challenge, at least for us, or just sort of capacity. These are more complex investigations, or can be. They can require more fact-finding. They may not proceed the way a normal kind of wage hour audit or UI, and so I think trying to think about how do we cross-train, how do we get staff the tools they need to be able to do these cases, that is sort of something I continue to think about, I guess. So if we go to the next page, I also started brainstorming some strategies to address these challenges. So one, this is certainly not unique to the misclass world, but I do think that third party connection to a worker center, a community group, union, in some cases, competitor employers, right? That is maybe how you get folks witnesses willing to speak up or talk to you, or kind of inside factual information that helps you figure out, well, what are even the questions we need to ask for? What other documents do we need? All of those things. How did this work? In terms of confidentiality and limits on information sharing, I don't think I'm telling you anything anyone hasn't already thought about, thinking about data sharing agreements. We have, in some specific cases, and at least in Illinois, our tax agencies have felt comfortable, with the AAGs that serve them and represent them in court, having those folks be a repository. In other words, they can see everything that the agency can see. And they can see, by and large, anything the Department of Labor is sending them is non-confidential. And so while we have not seen everything, our AG's office has acted at times as kind of a repository for the sum total of information in particular cases, and that has been helpful. And then the other thing that we're really just beginning to explore, and we're exploring it at the moment in our equal pay capacity, but it's something I've thought about in terms of misclass, are academic partners. So our UI agency has an ongoing partnership with the University of Chicago that analyzes the quarterly jobs data and payroll data and other data and provides sort of aggregate reporting, right? And we have some equal pay data. And so we have now realized that the two agencies can use this academic partner with whom we each have a relationship to do some aggregate data reporting on what they're seeing with those two different data sets. And so I have some hope that that may be a way that because at the moment we, like you, Nicole, don't have a lot of good data. but I'm wondering about whether an academic partner may be the way to get some better data and to get some data that might otherwise be protected, but produce it in a aggregate, non-confidential form. Yeah, change in administrations and principles, you know, this is just sort of government, but I do think the more that your subgroups as you're forming them or your working groups or whatever can be at the staff level, the folks that are signing out these cases, that is, I think, hugely helpful because they can still pick up the phone and reach each other by and large, usually. And I think that's the way that any of this work really gets ingrained. And then on staff training, you know, I think that the cross training and again, involving the staff, having the staff have opportunities to learn from folks at other agencies, how they do their work. You know, even we've done some trainings where we're almost like role playing a possible case or like a complaint comes in. How would we look at it? What would be the information we would do, and kind of workshopping that has been something that I've seen, you know, be a successful tool in getting staff kind of aligned on what other sister agencies need to know, how do they operate, etc. And I think that's all I had. I know I talk fast, but I'm eager to turn to the discussion.
Yeah, well,
After
thank you
Chris.
so much. I really appreciate your insight and your length of time looking at these problems and thinking about them from multiple different vantage points is, I think, especially helpful. Chris, you're up if you're ready. Thank you.
I am ready. Hello, everyone. Commissioner Burke, thank you for this opportunity. I'm honored to be here talking to all of you. Director Flanagan, it's great to see you. I'm going to say first and foremost, please nobody read into the fact that I don't have a PowerPoint as any sort of indication of how I view this issue or how Pennsylvania views this issue, because it absolutely is. It's a persisting and very difficult space. It exploits a lot of people, a lot of workers. You know, I think it's so unique in governments to have, especially these days, an issue that is truly should be apolitical. And this is one of them, right? This is one I know that when Pennsylvania was working on its task force, and still the messaging of, you know, it doesn't matter if you're, you know, if you happen to be more pro-business, pro-worker, wherever your interests are, this is really an issue that no matter how you look at it, it affects someone negatively in that space. So it's really an opportunity to be able to bring both sides of the aisle together. At least in theory, I will say that the reality is that doesn't always happen. But nonetheless, it's definitely an important issue for sure. So it's exciting to hear that Maryland, you guys are taking this up and looking into it. I will talk a little bit about Pennsylvania specific experience with our task force. There are some nuances. My big takeaway already just listening to first Minnesota, Illinois, is I was reminded about there's just these themes and everything that you've heard already mentioned is true for Pennsylvania. It's just the more we started looking into this issue, the more we found that the states that were ahead of us and looking into it found the same things that we found. It's kind of an issue that the more you look for it, the more you see it. I mean, it's really there in all sectors. So like I said, I do want to give some perspectives from Pennsylvania's point of view. And unfortunately, you know, whenever I'm on calls like this, I'm often reminded about some of the states, some of the laws that other states have. And I'm so jealous that I wish we had some of them. And ultimately, I guess I'll lead with that. My understanding, you know, obviously I wasn't I'm not a part of the legislature in Pennsylvania, but my understanding is New Jersey had first gone and done a task force in the late 1819 in that neighborhood. But that got the attention of our General Assembly at the time. And just really the issue of misclassification really caught a lot of people's attention. And that led to our General Assembly enacting a law that created a 2-year task force starting in 2020 and ending in starting in 2021 and ending in 2022. So since the end of 2022, our Pennsylvania also doesn't have a standing task force, unfortunately. But the mission of our task force was to first identify what laws exist and what tools exist in Pennsylvania to combat the issue. What are various agencies doing? To hear from stakeholders about what issues they're seeing. And then ultimately, the final charge with the task force was to issue a intermediate report, and then also a final report with kind of all those findings. Our task force was made up of a rep from the labor and industry, which is where I am now. Although at the time I actually worked for the Attorney General's office. Secretary Walker, now at Labor and Industry, was the AG's representative, who says hi, by the way. She wishes she could be here, but unfortunately a scheduling conflict precluded her. But she does say hi, and she also expresses her gratitude for the opportunity to be here and that you guys are looking into this. But in any event, we had our task force was the Attorney General's office, Labor and Industry, our Department of Revenue, and then both the Senate and the House got to appoint a majority and minority member. So we had seven members, and we met every month, once a month, every month for 2 years. The first couple of months was really informative to really just take a step back and hear what other agencies, what tools they had in their toolboxes. Like I said, at the time I was at the AG's office, we had one law, still has one law that affects or touches only on construction. Labor and Industry has a couple others. I'll get into that in a second. But we spent the first couple of months just hearing what exists. First and foremost, to the extent I can make a recommendation to the Maryland Task Force, that would be my first one. If you haven't yet, having a real understanding of what laws and authority each agency has, and specifically also what gaps exist with each agency and the ways you guys can piggyback off each other, I think is critical. I don't think you can meaningfully attack this issue or have an understanding of what you can do in this space until you know what everyone cumulatively can do. So that was a very informative first couple of months. And then we pivoted to stakeholders, which I would highly recommend. I don't know how much outreach you guys do in that space, but it was really informative to hear from. We had local district attorneys' offices come on. We heard from stakeholder trade unions. We heard from New Jersey Commissioner at the time, Estelle Arcaro and Angelo was willing to talk to us. So what you're doing now, I think, is wonderful to hear what other states are doing. Legal nonprofits, their representatives from the gig economy, chambers of commerce, to get everyone's perspective was really informative, and that took a lot of time. And then ultimately, like I said, we issued a report, which I'll talk a bit about that in a little bit. As far as how it presents in our state, again, it's not going to be shocking to anyone. It was prevalent in 2019. We had data in our report from 5 years ago already. At that time, it was estimated that 400,000 Pennsylvanians were misclassified. 50,000 employers were misclassifying someone. Of the workers who were misclassified, 12,000 were denied workers' compensation, which is a staggering number. And then the estimate, this always makes me chuckle a little bit because of the range, but the estimated loss of revenue to our general fund was between 6.5 million and 125 million. So it's quite a gap, but we can say at least 6.5 million 5 years ago. And again, I mentioned that because this is an issue. I'm sure that every single state government needs more money. Everyone's looking to save money. This is a space that if these funds are out there, if there's truly a will to go after them and to shore up that these loopholes that exist. So it was prevalent 5 years ago. That's all to say, and it's only gone increased since then. The trades or the industries that are affected. These I'm sure we're all aware of this. Gig economy is massive, pretty much built upon this classification. Construction is huge. Home healthcare, we're seeing a huge increase in the home healthcare space. Hair and nail industry, restaurant industry. But I would say sincerely, it was harder to find an industry that didn't have some form of misclassification than to list off all those that do. I mean, it just, again, everywhere you looked, it was there. So then what kind of authority exists then for the task force? And sadly, this is still the state of affairs in Pennsylvania. The agencies that have statutory authority, Labor and Industry, the Office of Attorney General, and then our Department of Revenue. The L&I, Labor and Industry, has the lion's share. Our Bureau of Labor Law Compliance, which is one of the bureaus I oversee, enforces our traditional wage and hour laws, but it also enforces our construction workplace misclassification civilly. So that's my most direct involvement with this issue these days. Under Act 72, the construction workplace misclassification, our Office of Attorney General has criminal enforcement authority as do local district attorneys. I'll just use that as an example. That's, again, it's critical to understand what authority exists for whom. So discovering that, or the fact that local DAs have criminal enforcement authority, it didn't take much outreach to find out that almost no DA's offices were looking into this issue. We were actually able to put it on the radar of some DA's offices. There are some unique challenges here. I'll try not to go too far down this rabbit hole, but a lot of there we found we had to do some educating to DA's offices, because labor crime is not viewed that way in DA's offices, right? There, it's the more bread and butter, homicides, drug theft, etc. There was a lot of pushback, and understandably so, right? They are also understaffed. Resources are an issue, but we had some pretty interesting conversations, just highlighting it and flat, and even I always find so compelling the example, which isn't mine, but I just find it so compelling that if a worker steals from the employer, lock them up, no doubt. But you flip that around, and for some reason, like, people don't have that same mindset about how they don't view that as theft. Not to say people should be locked up, but they just don't view that it doesn't, for some reason, that doesn't go the same way. And just having some conversations, we found, was very productive. We actually got a couple of DA's offices to start to take those, who now consider this as a part of one of the crimes that they do enforce. So anyway, I was getting back to, so Elle and I, we have our accessing to a construction workplace, but then also under all of labor and industry in Pennsylvania is housed our unemployment comp and workers' comp. The only other agency that has any authority here is the Department of Revenue, but they candidly don't have a lot. And they're, to the extent they are concerned about misclassification, it's a different lens, right? They're really more concerned, as they should be, pursuant to to what their agency does with collecting tax revenue. I don't want to speak for them, but there was just not that same element of making sure, whereas like L&I is kind of has more the vantage point of the harm to the worker, in some cases, like literally if you're workers' comp, but revenue, it's not quite the same mission, right? The mission is to collect revenue, and ultimately they can collect revenue. It doesn't matter how you're classified, as long as people are paying their taxes. Now, that's not to say there's definitely a concern, because as we all know, people who are misclassified tend not to pay their taxes are not being paid. But I just want to highlight one of the challenges is like that, like different agencies, even if they have some authority, may not have quite the same vantage point that other agencies may have. It's just the reality of things. But we are fortunate now, being at labor and industry, three boroughs that have statutory authority. All three have different tests for what constitutes misclassification, in addition to a common law standard. So I know this was a mention, or I think it was Director Flanagan mentioned that someone did, that the inconsistent standards of what constitutes misclassification was and is a major challenge. Again, even at L&I, you have 4 different standards when common law, UC, workers' comp, but kind of turning that into a positive. Like I said, what's happened here to L&I is taking a step back, and UC, actually the UC law has subpoena authority. They have the ability to do spot audits. For labor law compliance, we are more of a complaint-driven bureau. It's not to say we can't do our own, initiate audits, but it's hard to initiate an audit when you don't have subpoena authority. It's not impossible, but it's hard. So learning that our workers' comp, or unemployment comp, has this authority that we don't have. Today, there are 3 bureaus that all have enforcement authority in this space, all collaborate phenomenally. Whenever any one of them gets a indication of possible misclassification, it's referred to the other 2. This happens at kind of a macro level, where just the directors of each bureau has been informed that this is a priority and this is something they should do. So there's no need being internal. We don't have an MOU or anything like that, but it's just understood. This is how we want this happening. The secretary wants this happening, and it does, and it works really, really, really well. I see Portia has a question.
I know we're still in presentations, but I kind of didn't want to let that piece go, but maybe I'll hold. I have a question about that collaboration because I think we really want to hear more about that. So
I'm glad to hear
maybe
that.
I'll just flag that, and if maybe you want to finish, then we can come back to it. But I'm really curious about that point.
I was worried you're going to say I've been on mute for the past 15 minutes. So I'm happy that was not your question. Okay, so that's okay. So different standards that exist, a major challenge. Yeah, okay, I can move on to the next point. Some of the problems and challenges that we saw from the task force and just generally in this issue, first and foremost, inconsistent statutory standards. It can be challenging to find out where misclassification is occurring. As I said to you, despite the fact that it's occurring everywhere, you still need to, being mindful of limited resources and wanting to kind of do the most good we can in this space. It's a challenge, is knowing where to focus resources and where to focus attention. Depending on the types of classification, this will vary, this next point, but I think it's fair to note generally, these tend to be exploited workers. When you have exploited workers, you tend to have non-native English speakers. So there are language challenges, right? I'll throw into the mix now. There will be challenges depending on what's happening at the federal level. I'm sure we're going to see a much less willingness for people to come forward in the next 4 years than maybe they would have been the previous 4 years. So that's a challenge, is getting people to trust government to come forward. Not an easy answer there, other than just kind of building trust as much as you can, but that's an immense challenge. Education is a major challenge because, first of all, you have a lot of people who I will always believe do this intentionally, but you have a lot of employers that don't, and they just sincerely don't know what the law requires. Not shocking when we have, again, 4 different standards at least that they have to try to follow. So educating employers so they know what standards and what the law requires, but also workers. A lot of workers, people know if they don't get paid, they know, but people don't know if if they have been misclassified, and they don't know what protections come with being, classified properly. So that's a major challenge that still is just educating people in this space. And letting people know what their rights are so they can even know that resources may be available. Touching upon that, another really interesting challenge is a lot of workers in this space don't mind being misclassified. Now, they mind whenever, people are injured and they go collect unemployment or workers' comp, or they are laid off and they want unemployment and they find out they don't have any reportable wages. Or that their reportable wages are not accurate, and then that affects their benefits, or things like that. But in general, and it's also understandable. It's obviously we're all aware of the issues right now with people living, the challenges with wages and inflation, and I'm certainly can understand people wanting to just get paid as much as they can today and worry about tomorrow later. Nonetheless, it's a challenge. When ostensibly the group you're trying to protect doesn't necessarily want to work with you to be protected. No great answers there other than to be aware of it. Education again, and trying to have people be aware of the bigger picture. The fact that what misclassification can mean to and how it can hamper their ability to collect benefits now and employment down the road. We found that's a little bit productive or helpful, but it's challenging. As far as collaboration within our state, I'll just note, briefly with the task force, it was more difficult. The prospect was more challenging than I think a lot of people anticipated. Primarily with for example, I use labor and industry and revenue. The Department of Revenue has statutory restrictions both federally and at the state level for what they can share. So they would actually have to. It was. I forget the nuances, but I just know there were legal prohibitions for what they're actually even able to share. With going from civil and criminally, L&I and AG's office, that relationship worked easier, but also there were things to be aware of, right? If an investigation started civilly, you had to be very aware of what evidence was gathered or shared, because there are different standards of proof for what you can even obtain legally criminal. So those are not insurmountable by any means, but you need to just be aware with it even with how a case originates, there are different standards of proof for getting, issuing a subpoena or a search warrant, and then that may not translate necessarily to the other agency. So, but all that being said, at a high level, I can say that we were able to establish, at the time I was at the AG's office, and I'm benefiting it from being at the LNI. But there's a good collaborative network there, and when appropriate, we certainly refer cases back to each other, still today. So I guess I'm going to stop there. Well, a few more closing points. Ultimately, our task force, I think the hope was that, the task force would make recommendations that would turn into some legislation. And sadly, that just hasn't happened. So again, especially Minnesota, I was very happy or jealous to hear all the laws that you have, because a lot of the things that your law seems to have, and New Jersey for sure, were things that were recommended by in our final report. The big ones that we saw, there's a major gap in the criminal penalties that exist are just a joke. The phrase of the cost of doing business, it doesn't matter. I mean, they're just so minor criminally that people don't take them seriously. Civil isn't much better. So, it needs to be an enhanced criminal penalties in Pennsylvania, for sure. A uniform test for all industries. It would be a lot easier to enforce misclassification if every single industry knew what the standard was. Contract registration is something that would be very helpful in the construction space specifically. L&I having stop work orders and subpoena power, we don't have that. Private right of action was something that was on our list of 15. The ability to impute liability down the chain and up the chain if you see. So a lot of the same things that, frankly, we see other states doing, or at least recognizing as where you can do some good in the space is what ultimately was in our report. I will circulate, and maybe you can just Google it as well. It's a public document, both our reports. If you just Google Act 75, Pennsylvania Act 75 misclassification report, but I also let Deb Key know that I'll send it to her after this. But like I said, as far as like final recommendations, I already said the first one I wanted to say was that you just take it, to the extent you haven't yet. I heard from the introductions initially, you have a lot of groups on this call. It sounds like to me, you have all the right agencies. Just figuring out and being crystal clear on what authority each of you has and what you're able to do will really kind of necessarily guide your how you can proceed forward and how you can address this issue. But also being mindful, this is also another point that Director Flanagan mentioned, but I want to emphasize, right? At the conclusion of our task force, I think there was a lot of enthusiasm about working together and really building on this. I think there was some hope that there'd be some legislation passed, but ultimately, that hasn't happened yet. It happens every once in a while. Someone will propose a bill that mirrors the task force recommendations, but it hasn't been passed yet. So to the extent you can, just being mindful to whatever good you're able to do or whatever you're able to set up and establish, hopefully it would result in legislation. That'd be fantastic. But if it didn't, just being mindful about the fact that you all, may you all be here forever. But chances are at some point, the government, obviously people are going to move on. And just, what steps can you take to enshrine whatever you're able to accomplish to have it live beyond you? And it could be MOUs, it could be what have you. I mean, but just being mindful of that dynamic, that whatever you're able to accomplish with this group and with this mission now, to have it, make sure it doesn't end with this administration or with you folks, would be something I'd recommend to be mindful of. So I also speak very quickly, so hopefully that wasn't too fast. But with that, I will wrap up my presentation.
Thank you so much, Deputy Secretary. Really appreciate all of the insight. What strikes me is although there are many commonalities between the three of you who have presented, and you're at different places along a road, that you are all quite clear about at least what some of the underpinnings are that, make for, a successful, or at least as successful as possible, attack on this quite universal issue. And I know Portia had a question. I think the way we're going to try to do this, just for everybody on the call, I'm sure there are many, many questions. We'll obviously start with the secretary. What I'm hoping for is that folks who have questions, and I guess I should say I include the other presenters in this as well, because it's an opportunity for the three of you to talk to each other also. So I feel like don't be shy about doing that, but just raise your hands. And I think I've figured out the raise hand thing, and I'll just call on people and we'll go from there. All right. Secretary Wu, you're up. I
was wondering if not just Pennsylvania, but the other presenters could also speak to this, get a little more specific on the coordinated enforcement piece, because I think that is, we've started a motion of sharing information, but and then how do you make that kind of a little more formal? Also, it sounds like a joint intake form is one way, but I know it can depend on like individuals and relationships, and how do you avoid like stepping on each other as well? So like, do y'all meet like over and over and go through the cases? Like, do you like what are some of the key things that have worked well or not?
So I'll go first if that's okay, from Pennsylvania. And like I said, it really depends on that question. Very, very lawyerly response, but what you're talking about. So internally at L&I, it was like I had mentioned earlier, it was much easier for us to set up that referral and that collaborative network. I think it started with a clear directive from the secretary that this was an important issue. So that was as simple as letting each of the three bureaus that are in this space know that this is something this is on the list of priorities. This is something everyone needs to have their eyes open for. And there was no great rocket science behind how they work. Like I said, it's just the three bureau directors work really well together. And they, not having been given that mission, whenever any one of them, and they tell their teams, sees any complaint or any matter that looks like it could be misclassification, they refer it to the other two. That being said, it tends not, more often than not, because I think in Pennsylvania, our unemployment comp division, like I said, has the broadest authority. They tend to do the lion's share of the investigations. I'll never admit that to the folks that I work with, but it's the reality. It's just because they have the most authority. It makes the most sense for them, and they have the ability to do their spot audits. So they end up doing most of the investigation in that space. When they wrap something up, they will coordinate with the other two to see and cross-check to see if there are any additional fines that should be levied or any additional penalties that might be applicable. So internally, it's a very informal, and it really is. I make it sound as simple. This happened before I was here, but it's my understanding it was really as simple as just the message that this is our priority. And if that seems to be working for us. I guess it may not work for other states or not, but for now, as far as, like I said, candidly, working with other agencies, we do have an MOU with the AG's office and also revenue. With revenue, it just hasn't gone as well. It's not to say that they're not willing, and vice versa. It might be a product of that we are busy. We're already pretty busy doing our own work in this space. But it's just with revenue, we do have an MOU with them. But candidly, there's an opportunity for us to I think do more in that space. AG, we have an MOU with them as well, and it's the same thing. It's just that the directive was given to our folks that if you see something that could indicate criminal conduct, be aware of that. Tell your investigators to be aware of it, and then it just goes to the referral channels, and then vice versa. So that's how it is in PA.
Director Flanagan or Commissioner Blissenbach, would you like to speak to the Secretary's question?
Yeah, I can add a couple things in. I think we're still kind of on the early end of our partnership. But I would say having the partnership enshrined in statute definitely makes it commissioner proof, as we like to say here. So having that attention brought to it, as well as the obligation to report back to the legislature every year on the inroads the partnership is making, I think holds us a little bit more accountable. But we've also had the same kind of directive from the top that this is a priority and we need to figure out how to work together because clearly the problem's not getting not getting any better when we're just doing our own thing and not coordinating or communicating. So I think there, you know, with the work groups that we have focused on data sharing specifically, which, you know, has included identifying which data is held by the different agencies, which is sometimes unknown. And then determining which, you know, which of that data will be helpful in investigations. That'll be a key piece. And then developing those procedures and protocols for, you know, deconfliction if we need it, identifying who may have the best resources for a particular case or complaint that comes in. Being able to just talk freely about those things, I think will go a long way. But we're still in the very early stages of that part and plan to build a lot more into it.
I don't know that I have much to add. The only thing I would add is, so, you know, we sort of have a quarterly staff level meeting that is just kind of set. And we have that, as I said, that sort of automated referral system. So there are certainly things that can be discussed quarterly. I, though, have really tried to emphasize that when, like, we just got a referral through a community group, a group of workers had come to them. They had worked for a place as W-2 employees for years, doing a job. The place was purchased. They were re-verified. And those employees that could not provide, they could not pass employment verification were told that they would, starting, you know, the following week, be independent contractors and would be working for like a third-party company. And so that to me, and it was like, you know, we even had the communication from the employer out, you know, the all staff essentially. And so in a case like that, where it seems like, okay, there's probably definitely something here. This is complex because you have a business going out of business, you have a new buyer, right? Like in that case, I have really said, like, pick up the phone, organize a meeting, like, let's collaborate on the front end. Whereas I think what often is happening is kind of like parallel investigations where people are in touch. I think there are times or instances, I raise that because I think there are instances where coordination from the beginning, from the outset on the approach and who's taking lead and all of that makes sense. That is not going to be the bulk of cases. I think the bulk of cases are still just going to proceed under people's different tests and people are going to be in touch. And to me, that's kind of just the reality of the numbers. But where there are significant potential violations or cases or higher impact or, you know, some of these other factors, I think those are your opportunities to kind of think about what just more robust joint enforcement look like.
Thank you, super helpful.
Yeah, I have 10 million follow-on questions, but I know Commissioner Quinn had her hand up. Commissioner Quinn. You're on mute.
All right, sorry about that. It feels wrong to go before you. All right, you called on me.
No, not at all.
Okay, thank you. I'm the chairwoman of the Workers' Compensation Commission, and I've taken a particular interest in these commercial construction zones. And I'll briefly say what we all know, which is that construction, particularly in commercial construction, is being built on the backs of Latino labor that's all misclassified. So we know that, and when I'm really very interested in this Rivian case, and I'm wondering whether that case was brought after the plant was built, because what I've been told is if I try and make a commercial construction zone all W-2, there are not enough documented workers to build anything, and our economy will just kind of grind to a halt and nothing would get built. And to my task force members, this is some of the information I've gathered since we last all met. So that's why I'm curious about the Rivian case, because if you bring the case after the building is built, you get the benefit of collecting all the fines. But the building gets built.
Yeah, we brought it midstream. But we never filed. We forced a settlement.
Okay.
My view on that, for what it's worth, from an enforcement perspective, is you'll lose the workers.
Right.
You'll lose the workers.
Yeah. I mean, with the threat of deportations, I mean, you know, we may find ourselves in that kind of a labor shortage situation anyway, but it's been made very clear to me that the documented workforce in construction is very, very low compared to what the demand is. So I'm in search of a solution. So, all right. Thank you, Commissioner Burke.
Of course. I'm sure this won't be your only opportunity. Deputy Comptroller Robolino.
Thank you so much. Yeah, you all touched a little bit on educational opportunities and best practices. What can you pull out from like the top 3 or top 2 things that you found most helpful in educating, basically, you know, employers and employees?
I can go first.
That's for all of you.
Yeah, that it's really hard. This stuff is really complicated. Minnesota is not alone in that we have, you know, at least 4 different tests to determine the employment relationship. They have similar themes, but they are different, and it depends on what each agency is that is applying it. You know, other than our construction tests, they're all balancing tests. So that becomes very challenging. So, you know, when we're looking at kind of the education and outreach portion of this, it's how do you get across the big ideas of control and, you know, financial control and relationship and all of that without getting into the, you know, hundreds of questions that an unemployment insurance judge may ask in a unemployment insurance hearing. So trying to really take it up a much higher level so that people have what they need. And, you know, the majority of these cases aren't going to be close calls. You know, where we see misclassification, it doesn't have to be you know, we're probably going to find an employment relationship under all of the tests if we're going to find one under any of them. So I don't think it needs to be as complicated as it looks when we're looking at the different tests that are applied. So that's really our main goal in developing the education materials, is trying to bring it up a level so that we're really just focusing on what does it mean to be an employee? What does it mean to be an independent contractor in plain language terms?
Yeah, that's a really interesting observation, Nicole. And I'm curious as to, I know from Chris's presentation that one of the things that's a priority for Pennsylvania is trying to figure out a way to sort of level out the different tests for employee status. And it's certainly something that we have a group of enforcement staff that meet regularly to, you know, discuss leads and to talk about our authorities and, you know, in addition to specific cases, sort of think more broadly about how to streamline investigative methodologies and how to collaborate better so that we can each piggyback upon the findings of the other. And so this is like straight in the wheelhouse of that. And I'm curious as to what Chris's thoughts are, listening to what you said, Nicole, about how there are commonalities to each of these 4 tests. That's on the education side, but on the enforcement side, I wonder if you found that a similar kind of analysis can be useful, in that maybe you take the most restrictive test, because even under that test, all of the others will fall into place, right? I haven't thought about it deeply enough, but I wonder whether that is a possible solution, because it does feel to me to be difficult to get, particularly on unemployment and tax, like those tests I thought were kind of set by essentially the federal government. I don't know, maybe I'm wrong about that. And there are many people on this call who can stomp on me if I am. But if that were the case, and we assume that the tests are what they are, and that they're difficult to change, is there a way, or has any of you found a way or thinking about a way to sort of level up to the highest, most restrictive test and just build on that? Chris, I'm looking at you. Sorry.
Okay. So I think I would just say the premise, I think, is excellent. And if that would work in your state, that would be fantastic. That doesn't work for us, unfortunately, because, like, for example, our construction misclassification test is a version of the AC test. But the C, as far as the independent established business, there are statutorily identified, like a list of like 10 criteria that all have to be met to constitute an independent contractor in the construction space. So that would be something that would prohibit us from, like, kind of just identifying one and highlighting that one. I can't speak on that point any more than that, but I think that's a fantastic question. And if that would work in your state with your statutes, that would be, I don't see any, I think that'd be a great way to approach it. I was going to circle back just quickly as far as education. I think it also takes different forms depending on your audience, right? So what we found to be very effective is just taking advantage of press and press releases. Hopefully your offices are doing this already. Shockingly, prior administrations in Pennsylvania had a objective or a policy of not doing press. So we found that just that shift alone, which was a fantastic idea by Secretary Walker, has really gotten the word out, at least on the for both employees and employers, but primarily, especially for employers. And I say it because also what we've started doing, or at least making sure it happens whenever we can, is whenever we do have settlement agreements, or if we have ultimately to go to court, but as a part of some resolution is mandatory education for the employer. So that's not the most efficient way to do it, right? It's a one-off, but over time, I think the cumulative effect of always having education as be a part of that settlement package will add up to something over time. And then as far as our approach to take advantage of getting to like workers and letting them just know about even putting the issue on their radar, exactly like Nicole had mentioned, you can't have an effective messaging, go be extremely detailed and nuanced. That's no one's gonna understand that. So you really have to kind of focus on just the bread and butter, high level. Hey, do you know you should be misclassification is a thing? I mean, just like a super high level, and then identifying people that as our, we have more information on our website, as you all do as well. But just highlighting the issue for workers in particular, and doing so right in this day and age. Social media is huge, so we really have made a priority taking advantage of social media and doing outreach that way as well. But like I said, specifically with not so much being concerned about the nuances of the laws or what's required, or it's just way too much detail. But just general high level, misclassification of the thing. I'm making this up, of course, but it's like just very high level messaging that would hopefully get people's attention and direct them to our website as more of a resource to get more information. And I can say, people call us all the time, employers and employees, with questions. I can't speak to what it was like before I was here, and I don't know. We didn't track volume of people who call us, but we are often getting called by people with questions in this space. So we're definitely reaching some sector of the population.
I would love to talk with you about your campaign, because that is a challenging, if you look at it in the legal framework, it's a challenging thing to communicate. But as you say, and as Commissioner Blissenbach also mentioned, trying to figure out what is actually the message that you're trying to convey. You're not trying to convey what is the legal test for this. You're trying to say, there's this thing, it could be a problem for your business or for you or for your family, and how you talk about that. Yeah, anyway, more to come, I'm sure, in follow-up conversations, but I think a really important takeaway.
Let me say really quickly, I mean no disrespect, but there's too many commissioners and directors and so when I identify someone by their first name, I mean no disrespect to anyone. So just to be clear about that.
So. I always insist on commissioner, even from my close family. So nobody abides by that, but that's fine. I'm kidding. Thank you. Others with questions? Commissioner Quinn, did you have a question as well?
Yeah, well, I always, yes. So, are any of you finding that some of the big payroll companies, but obviously the big ones, are exacerbating the problem by not insisting that their clients carry the proper insurances? Because we're beginning to see that they are playing a role in this. You don't want to push too hard on your client when they say, I only have independent contractors, but you're writing the checks, every week and handling the payroll, and these people are employees. But if you insist, then they're going to go hire a new payroll company. So that's something that we're looking at. I wonder if any of you have any thoughts on that. Thank you.
I agree with you that I think payroll, the big payroll companies are by and large just saying, okay, these are your 1099s. Like there are 150 of them, just, process. I don't think they're asking those questions necessarily. I don't know that we have really, I mean, to me, it's still the employer that's providing that guidance, and that's where the liability lies. And so, but maybe some further education there. I mean, that, maybe there's a potential for education, to sort of make those companies potential sources of information or allies, I think is an interesting question.
Sorry, I there. I was just gonna say, I think that we've seen the same thing with some accountants, where you see entities sending people to the same place, like this is how you go and get all the proper paperwork that makes it look legitimate. We actually had a criminal prosecution in Minnesota of a company that helped everybody fill out, all of the paperwork to get their work comp, their low risk work comp policies, to fill out their contractor registration forms and file with the department, even paying, fees on behalf of the workers that they were registering as independent contractors. And there was a criminal case on the work fraud or work comp fraud aspect of that. So we do see it, and we know it's a problem, and there have been lots of attempts to try to track data on, is there a common denominator when we're finding these violations? And if so, how do we go and kind of attack that issue at the core? But it's hard. It's sometimes hard to track that data and find that common denominator. But I'm guessing payroll companies and accountants are all there.
Yeah. Well, under the previous iteration of our Maryland Joint Enforcement Task Force, during Jane's time, one of the recommendations that ended up actually being adopted was to hold accountants who knowingly assist in execution of workplace fraud accountable. That said, to my knowledge, and it's possible that others who have been here longer would know better. To my knowledge, there has not actually been a prosecution under that. They may have been citations under it. There may have been settlements under it, but that mechanism, I think, exists. How effective it is, I'm not sure. I do want to ask a little bit about I understand Minnesota has a private right of action right, on workplace fraud. So does the Maryland misclassification workplace fraud statute, which is construction and landscaping only, but it does have a private right of action. As far as I can tell, and I can't say it's 100% exhaustive, but there's like no case law on it, even though it was obviously something that was really hard won in our General Assembly. And there are issues with our statute. I'm curious, maybe it's too early to tell as to sort of the effectiveness of a private right of action in this area, sort of given all of the incentives or disincentives that have been discussed here, from both the worker side as well as the business side. What has been Minnesota's experience with that? I'd be curious.
So the private right of action outside of the construction industry is new. That was added just last session. We had the private right of action for misclassification in the construction industry. And as far as I'm aware, there's never been a case brought, at least not one that would have a public decision or settlement agreement. So I'm not sure, but I can also add, when we added criminal wage theft to Minnesota statute back in 2019, we've only seen a handful of criminal wage theft cases brought. I think it's 3, and they've all been kind of resolved without there being public information about how those were resolved. So where we are seeing the most criminal enforcement action is work comp fraud, premium fraud, which is great, but of course, any recovery then goes to insurers, not the workers. So that's where we've seen the biggest highlighted cases in the criminal area.
Really interesting, right? I mean, part of the reason, as Chris mentioned, that misclassification occurs is because it's a bit of a deal with the devil. Both sides get something out of it. And often people are paid more in that, under that arrangement than they might be, right, as reportable W-2s. And so they want to get paid. They got paid. What's the incentive then to go prosecute their employer? What's the incentive to file a criminal complaint? Like, I do feel like incentives is a big part of this. And even if one were to put aside the immigration issues and the fear that comes from from maybe not having work papers and being vulnerable, the incentives themselves, even if you take all those things out of the equation, are just not even. Sorry, I see my secretary's hand up. I apologize.
No, that's super useful. I had a question based on something that Chris said about getting calls all the time. And I know we're also starting to get some more sort of inquiries, as we change direction of enforcement and people are seeing more visible enforcement and expanded unit. In other labor contexts, we sometimes have, and I'm thinking like the pensions arena, other areas, we're sort of like, okay, occupational safety and health, we have a consultative service. If you're not sure if you're appropriately classifying folks, or you're not sure how to get to the appropriate path of, okay, I need to switch my people over because they obviously are W-2, but I'm not exactly sure how to do that. Do you all have like consultation or hold harmless, or have you heard anybody doing that? I hadn't really thought about it till now, but yeah.
I can speak to that. We only have, formalized consultation in the OSHA world where we're funded to do that. I do, we do quite a bit of compliance assistance to employers. We hold webinars, we speak at seminars, we provide our number, we are willing to talk to them. I've really come to believe in this job that employment counsel is really our overwhelmed government, agencies friend, in that often they are the ones that are actually steering the employers to follow the law. But we don't do it in a formal way. And obviously we don't give specific legal advice. And, we always say this is not legal advice based on some of the facts you've described, and not knowing all the facts. Here are some things I would consider, that kind of thing. But we do quite a bit of that.
And I'll add to that, same in Pennsylvania. It's very, takes very seriously the mission of educating and helping people come into compliance instead of just, penalizing folks for not being in compliance. Not to say it never happens, of course, but I also think it's just kind of in this space, you don't tend to have highly sophisticated, multinational corporate conglomerations calling to ask about misclassification. Like it tends to be the smaller mom and pop shops or a worker here and there. And so I think almost, and maybe we're just playing with fire, and at some point we will have to cross this bridge, because you do raise some really interesting points. And I don't know exactly how we would handle that, a situation that you raised, Secretary. But, luckily in general, like that's just not the type of call that we tend to get. It tends to be more of a sincere low-level attempt to come into compliance versus some indication of like rampant statewide, millions of dollars of misclassification at stake. So
I think the other benefit about, sorry to jump the queue here, about doing proactive outreach to employer groups, particularly in high misclass industries, is that you then get the competitor employers who are blowing the whistle on the folks that are, misclassifying their workers and therefore able to get the contract or outbid them or whatever. So we've certainly seen that in the, for whatever reason, we have a nurse agency. We regulate temp nurse staffing and nurse aid agencies. So we did a whole proactive thing in that industry when these amendments passed. Long way of telling you why we were doing this outreach to temp nurse staffing and medical staffing, right? But out of that, we actually heard a lot from staffing agencies in that industry that their biggest concern was that their competitors were misclassified. So we weren't going in to talk about misclassification. We were going in to talk about the law and their obligations under the law. But that was something we were hearing from competitive employers.
Yeah, that's huge to be able to have, kind of a weigh in on a particular sector where there is a lot of misclassification, raise the issue and have it bubble up. That's at least, that's a big step down the road towards trying to change standards within an industry, right? There has to be kind of collective will. And part of it is, what do you do to trigger that will? Like there's, the stick side, right? But I completely agree with what people have said here, is that you can't, you can't find everybody, you can't do everybody. And for some, the penalties aren't going to be high enough. And in fact, you're just not going to catch everybody. That's not the way this works. There's got to be a norm. And, you've got to change those norms. And so what you're talking about is a really important step along the road to doing that. Oh, I see Commissioner Quinn, your hand is up.
Yeah, I wanted to segue on off of what you had said and what Jane had said about you have to do education of an entire industry, and you have to do enforcement against an entire industry. Otherwise, that's what they do. They call on their competitor and they rat them out, and then they get the business. And so that is, one of the things that we have to be mindful of as we do enforcement. Chris, you mentioned the nail industry. Here's another whole industry, an entire generation of Asian women misclassified. And, are we going to do that, for another generation? And I wondered if any of you had tackled this problem in your state.
We have not focused specifically on the nail industry because it's not where we have specific misclass authority, right? So where we get a complaint, we'll assess the overtime, we'll do the test, but it has not been a particular area of focus for us. I know New York AG's office did a whole nail industry focus
expose, yeah,
many years ago, but for what it's worth.
I read that, taught it in my class.
And I do want to, I guess, clarify to just, we also haven't targeted any specific industry. I was listing those as examples of where we're seeing increased prevalence of complaints coming in. I will say we are hoping to build up and do some more strategic enforcement. But in particular, that one is as an example, well aware about the violations happening in that space. I don't think we've ever gotten a single complaint. So that would be something that there are challenges about, definitely language challenges. And it's on our radar, but just to be clear, we also haven't done specific work targeting, and frankly, any of the areas I mentioned. That was really just to highlight some of the trends, some of the most prevalent violators that we're seeing.
Very helpful. I want to make sure all the task force members, you know, and designees. I know we have MIA on here. You know, we obviously have UI and professional licensing, which is very could be at least potentially a powerful tool. And obviously the Office of Attorney General. We've had an amazing conversation, but we've got 11 minutes left, and our folks have been really giving up their time. Please raise your hand if you've got questions or observations to share. Heather.
Yeah, just curious in Minnesota and Illinois, where the AG and the Labor Department will have sort of concurrent jurisdiction. Can you speak to how that works?
Sure, I'd be happy to. And Chris can speak to this too, in that he also came from an AG's office, right? So I've been the AG side labor enforcer, and then I came over here. So that helps because I know the folks. But I would say by and large, how it has worked, well, two ways. So there is a unit of the AG's office that continues to litigate represent the department in court on administrative enforcement actions. At DLLR, I know those folks are within your agency. In Illinois, they are within our, we have a much more centralized AG's office than you do. So that unit still exists. They still just represent us in kind of bread and butter administrative enforcement actions, enforcing administrative hearing decisions, filing de novo actions. The concurrent enforcement piece of the Illinois AG's office is housed within the Affirmative Public Interest Bureau. And that's where I came from. They really tend to focus on bigger picture, strategic enforcement, high impact cases, big numbers, new laws, those kinds of things. And so the way that has actually worked really well because, we have very few lawyers here at the department. We do not have bandwidth to do those kinds of cases at scale. And we don't have enough lawyers to just do, discovery, for example, in those cases without that partnership. So like that Rivian case I referenced, the AG's office sent investigators, some of our investigators went on site. We talked to workers jointly. We issued joint subpoenas in that case. The AG's office did the bulk of that initial doc review, but they don't have on-site, authority. Their subpoena authority isn't always as good. So it's not every case by any means. And I think that's important. We have not viewed it that way. And perhaps because I came from there, I've been pretty clear-eyed about we also just need to do these individual cases and these small cases because workers need us to do that. And also we need strategic affirmative lawyers to be pushing the envelope and doing those high impact cases. And so we have tried to be really strategic about what falls in what category. And we did when our governor took over, he issued an executive order that actually ordered the department to refer the high impact or strategic cases to the AG's office. So we have an EO2 mechanism. We don't need it, but it has helped provide kind of a clear vehicle for us to identify those cases and queue them up and say hey, we think this is an EO2. This is one where we think we're going to need your support. We're going to want it from the beginning. It's not going to make sense to run through our administrative, investigations process. Let's think about this differently. So I don't know if that helps, but that's how we've done it.
Yes, thank you.
Yeah, and I would just echo all of that. I mean, it's very similar setup in Minnesota. We've got our AG's office division that represents us as the department. And then they have a what they refer to as their wage theft unit, which does its own investigations. Yeah, the ultimate goal is very similar to what was just described, in that they have the can do the bigger, high impact, novel legal theory cases that at the department would be very hard. Well, we have the on the ground investigative staff and authority to do some of the more fact intensive cases that don't depend on those novel legal theories. So that's kind of how it's been broken out. And and we meet often to make sure that we're not working on the same things, because we have plenty of stakeholders that like to refer to both of us without telling us that they referred to the other place. So we meet often to make sure that we're not duplicating efforts.
I appreciate that. And do both units have do they both have investigators, or do they does one rely on the other for sort of on the ground investigations, or?
Oh, Jane, you're muted.
Oh, I'm sorry.
Sorry. At least for us, certainly the folks that just represent us in, our administrative decisions, no investigators, they're just lawyers. They just represent us in court. The Workplace Fraud Bureau, what state am I in? What's the name? Anyway, the affirmative Workplace Rights. That's the name of our AG's bureau. The Workplace Rights Bureau, they do not have their own dedicated investigators, but they will at times rely on the sort of pooled AG office investigators. And they will also rely on our staff as well at times.
And the wage theft unit at the Attorney General's office in Minnesota does have a handful of investigators. It may only be 2 or 3, but they have a few of them.
Well, it's certainly those are all interesting arrangements, and I guess the bottom line is what actually works, and that a lot of that, a lot of what I'm hearing are the common themes here are really about collaboration, right? Among the agencies that have enforcement authorities, amongst different agencies that have different powers. That really seems to be a theme, and it's certainly. Obviously that's the genesis of a joint enforcement task force, is to figure out how do you enforce jointly. And that's, Nicole, to your point about trying to actually work through the details of how do you decide in a given circumstance, after flagging the potential issues, how do you decide who takes lead and what roles others play? Are there times where, there's kind of co-enforcement by 2 agencies? All of that requires a tremendous amount of communication and collaboration. And without it, no matter what anybody's powers are, none of this really works, right? So that feels like a foundational thing, kind of no matter what your arrangement or structure is. At least that's one of my takeaways. Task force members, 4:57 p.m. Last call for questions before we give it back to the secretary to wrap us up.
Well, and I hope, thank you. First of all, I want to thank again our colleagues from the states. We're just so grateful for your wisdom and just like being so frank with us and forthcoming. It's really we've learned so much from this. And I also want to thank Commissioner Virk for taking the laboring oar to pull all of us together. It's really been a rich discussion. And I know we'll have follow-up questions for each of you. And of course, want to make sure that to the extent we can be helpful to any of you, that we want to extend that offer as well. I do have a couple quick housekeeping things, but let's all give our guests a virtual round of applause. Thank you. Thank you, everyone.
Thank you so much.
Really appreciate it.
Thank you.
And then just for the task force members, the next meeting is on December 5th, 9:30 to 11:30. We are preparing our year-end report talking about the prevalence of list classification. So it's really interesting to hear also from the other states of, how did that report go? What did we hope we would get out of it? I have to say, as we're heading into our legislative session, we're already aware of some other proposals. Some of the member agencies here have some ideas. So I would encourage us to, let's all communicate about those legislative proposals. But I also want to make sure the holidays are coming. So please take a look at the recommendations of that report. We will, in our December meeting, have sort of a high level overview. I think that's the goal, to put it on slides for sort of public awareness. And then we will figure out some kind of process for public comment to come in. But I think the critical piece is at the next policy meeting and through the email circulation, we will need a fairly quick turn from task force members and their staff. So we really ask that you prepare your policy staff and your enforcement staff to take a look at it to see if the recommendations are going in the right direction. And of course, if there are ideas that have come from this or from our MBE meeting, which we had very recently, the stakeholder listening session, let's make sure that those recommendations are reflected in our final task force report. All right. I think that's it. With that, I think I am going to call this meeting adjourned. Thank you. Thank you.
Thank you, Jen. Really appreciate it.
Thank you. Good evening.
Thank you.
Thank you.
Good night.
Thanks so much.